I am Jeffrey Berger of the Berger Law Firm. Welcome to the 2013 Annual Legends of the DC Bar. So let us begin. So Justice, tell us about your background and family growing up, your high school activities, and your road to college, and in particular, could you include why you have a baton, a frame baton, hanging in your chambers?
Yep. You mentioned that I grew up in Brooklyn, in a typical Brooklyn area, which was roughly 1/3 Irish, 1/3 Italian, and 1/3 Jewish. I'd say that the overwhelming presence in my life as a grade school student was World War II. It was a time when there was a right and there was a wrong. We was fighting a war against racism, and at the same time, our own troops, when World War II began, were rigidly separated by race. And I think it was the years of World War II that made the country conscious that we did indeed have apartheid in America, and we had to change that. High school. I had two favorite activities, and one was playing in the school orchestra. I picked the instrument that I thought would be easiest to learn, which was the cello. And the other was my life as a twirler. The baton in my chambers was a gift from the National Association of Women Judges. So I think I learned not to like football as a result of freezing too many half times.
So you had a scholarship to Cornell.
Yes.
And what was it like there for you, and what did you, I know a lot of your life was influenced by people you met at Cornell, and your road to law school. Could you talk about that?
Cornell in those days, it was parents' dream for a girl, because there were 4 men to every woman. They had a quota system for the girls. The excuse was, we can't admit evenly because the girls must live in the dormitories. The boys can live in college town, so we can admit boys when there's no room in the dorm. Well, that was the ratio at Cornell. I went to Cornell in the early 50s. It was not a great time for our country because it was in the heyday of Senator Joe McCarthy, who saw a communist in every corner. I had a wonderful professor for constitutional law at Cornell. His name was Robert Cushman. I worked for him as a research assistant. And he wanted me to appreciate how far the country was straying from its most basic values. So I read Red Channels, which was the blacklist for the people in the entertainment industry. I read everything that Alan Barth wrote. Professor Cushman called to my attention that there were lawyers who were standing up for people who were called before the House Un-American Activities Committee or the Senate Internal Security Committee. These were lawyers reminding the members of our Congress that there was a First Amendment. It was our pride, and we were dishonoring it. So the notion was that lawyers could do some good for the community in which they live, and on the other hand, earn a living as well. And my family wasn't so sure about the earning a living part when I decided I wanted to go to law school. But then I mentioned Professor Cushman. Beyond all other people in my life, I met at Cornell when I was 17 and he was 18. My life's partner for 56 years. And when Marty and I married, when I graduated from Cornell, then it was okay with my family for me to go to law school because if I couldn't make a living, well, I had a man to support me.
They were very practical, but not accurate. I think we're getting some feedback on the microphone, so if you could adjust that a little, that would be really helpful. So you actually went to 2 law schools and served on 2 law reviews, which is extraordinary. How did that come about, and what were your experiences like at Harvard and then Columbia?
Marty was 1 year ahead of me at Harvard, and he looked for a job in the Boston area, couldn't get one comparable to the job he had in New York. To be frank, it was a very hard time for both of us because Marty is a young man in his 20s, had a virulent form of cancer in his 3rd year of law school, and we did not know how long he would live. My daughter was then 3 years old. I didn't want to be a single mom for a year, and we wanted to be together. So I went to the dean of the Harvard Law School and said if I successfully complete my education at Columbia, may I have a Harvard degree? And the answer was absolutely not. You have to stay here for the 3rd year. I had the perfect rebuttal argument. I said, well, my Cornell classmate, Rhoda Isselbacher, transferred into our 2nd year class after a year at Penn Law School. She will be here for year 2 and 3, and she will get a Harvard degree. You say the first year is by far the most important. A fortiori. And I was told by the good dean that a rule was a rule, and that was that. I must say that my current colleague, Elena Kagan, every year that she was dean of Harvard said, Ruth, we would love you to have a Harvard Law School degree. and my husband said, hold out for an honorary degree, which I received in 2011.
With Luciano Pavarotti.
Not he wasn't around anymore by then. With Placido Domingo.
Yeah, okay. Right. So when you graduated from law school, what were the employment opportunities and atmosphere like for minorities, particularly women and Jews, at that time?
It was just changing for Jews. I think Cravath had made its first Jewish partner when I was in my 2nd or 3rd year of law school. But these were pre-Title VII days. What my law school class looked like, we had over 500 in the class. Starting out, 9 were women, of whom 6 eventually graduated. We had only 1 African American. Employers were upfront about wanting no women. So the placement office would put up sign-up sheets for interviews, and they would say men only. But in my case, I had a 3rd liability. I was Jewish, I was a woman, but worst of all, I was a mother of a 4-year-old child, and employers were certain that I couldn't be relied on to show up every day.
Especially for the younger lawyers in the room who've never experienced that kind of discrimination, there were no discrimination laws at that time. The Civil Rights Act was not even a concept, and employers could just blithely say, "We don't want to hire you because you're a woman."
I think we just celebrated the anniversary of the Equal Pay Act was in '63, Civil Rights Act in '64, Title VII in '64. There were mixed motives for the Equal Pay Act because some proponents of it thought, well, if you have to pay the woman the same as the man, all things considered, the employer will hire the man rather than the woman who will work for less money.
So how then, with all this, this 3 strikes, essentially being Jewish, being a woman, and also being pregnant, how did you get started in your?
Not pregnant.
Not pregnant. Not pregnant.
That came later when I was teaching at Rutgers. My daughter was born 14 months before I started law school, so she was 4 when I graduated.
Can you talk a little bit about that?
I'll tell you how I got my first job in the law. And I did rather well in law school, but there wasn't a single legal employer in the entire city of New York who would take a chance on me. I had a professor at Columbia who was in charge of getting clerkships for students. Is the sound okay now? He called a professor who always took his clerks from Columbia, called a U.S. district judge. And he said, my candidate for you this year is Ruth Bader Ginsberg. And the judge said, well, I've seen her resume. She has a 4-year-old daughter. So Jerry Gunther said, give her a chance, and if she doesn't work out, there's a young man in her class who's going to a downtown firm who is ready to come in and take over. So that's the carrot. The stick was, if you don't give her a chance, I will never recommend another Columbia student to you. That's how I got my first job. It's very similar to Justice O'Connor's experience. She did very well at Stanford Law School, couldn't get a job. She volunteered to work for a county attorney free for 4 months and said, if you think I'm working, at the end of 4 months you can put me on the payroll.
So how did you move from clerking to teaching? I think there was a time of Sweden in between. Yeah. How did that occur?
Well, after I clerked for 2 years in the district court in the Southern District of New York, then the judge for whom I worked was able to say she shows up whenever I need her, even on a Sunday. So I got then there were a number of law firms that offered me a job. The head of the Columbia Law School International Procedure Project came to me and said, Ruth, how would you like to write a book about civil procedure in Sweden? So I wasn't quite sure where Sweden was on the map. But then I thought, this is an opportunity to write a book, something that I have written between hardcovers, to learn a language and a culture that was totally foreign to me, and to live alone for a while. You know, I had gone from a college dormitory to being married, and I never lived alone. So there were those 3 incentives, and I took 2 years out. I was on leave from a firm with which my husband later became of counsel. So after the Swedish adventure, I had a call from a professor at Columbia, well-known professor of administrative law, Walter Gellhorn, Walter said, Ruth, what are you doing on a Harvard list when you are a Columbia graduate? I didn't know what he was talking about. And then I remembered that Harvard had sent a list, a questionnaire. Are you interested in teaching? If you are, fill out this form. So I filled it out, forgot about it because there were no women teaching in law school at that time. And then I jumped to the wrong conclusion and I said, Walter, is Columbia interested in me? He said, not Columbia, Ruth, Rutgers. And I'll tell you why Rutgers was interested. There was a fine professor of civil procedure at Rutgers. His name was Clyde Ferguson. He was leaving Rutgers to take over the deanship of Howard Law School. Rutgers was considered an avant-garde school. It tried very hard to replace Clyde with an African-American male, but when they failed in that quest, well, the next best thing was a woman. So it was a bird in hand. And there were, across the country, less than 20 women teaching on law faculties. So if I said no to this offer from Rutgers, if I said I want to stay at the firm for 5 years, there might not be another opportunity. So that's how I began teaching it.
And I read that when you went to Sweden, you were sort of impressed by the roles that women had in Sweden. That sort of opened your eyes to women being more active.
Yes. Women were about 20% of the law students then. They were maybe 5% in the United States, not more. One scene, I attended a hearing with the presiding judge, 8 months pregnant. And it was a concerted effort. Sweden had rampant inflation at that time, so it was important for families to have 2 earners. But they hadn't gone quite that far because the woman was expected to have a paying job, but she was also expected to buy the children's new school shoes, to go to the school meetings, to have dinner on the table. So there was a column written in the Swedish daily newspaper by a woman named Eva Moberg. And it was to this effect: why should the woman have 2 jobs and the man only 1? It's not enough that he's willing to take out the garbage. And that, I began thinking, this is back in 1963, about her question, why should the woman have 2 jobs and the man only 1? And
I remember, because it was back in 1970 when I started at Rutgers, we had, I think there was almost 50% women in the class at that time. But I do remember when the Women's Rights Law Reporter was just getting started in your course on sex discrimination against women was being started, how exciting and extraordinary it was. Could you tell us how you became engaged in the fight against gender discrimination at Rutgers, and how did that begin?
there were 2 forces that were working on me at the time. One were the students. NYU had a course on women in the law, and a delegation of students from NYU came to Rutgers. We had a meeting, and the students asked if I would teach a course the following semester. I went to the library, and inside of a month I read every federal decision involving women's rights or the lack thereof, every law review article, and now that was not a big deal because there was precious little. There was, I think there's as much produced in a month now as there was altogether. So there was that. And then I was a volunteer lawyer for the American Civil Liberties Union when new complaints started coming in, complaints of the kind they had not seen before. One type were the pregnant school teachers. In those days, they had for women teachers what was euphemistically called maternity leave, which meant the minute you begin to show, you're out of the classroom, because after all, we don't want children to think the teacher swallowed a watermelon. And it's unpaid leave. If we need you after your child is born, we will call. There were many women whose view was, we are ready, willing, and able to work. There's no reason that we should leave the classroom just because we're pregnant. So that was one category of case. Another was a woman working at a plant that had a good health insurance package. And her spouse's employer didn't have a comparable plan. So she wants to take health care, not just for herself, but for her spouse and children. The pervasive rule then was a woman worker can get only coverage for herself. Family coverage is available only to a man. Those were the kinds of complaints. Another complaint was at Rutgers itself. In the 70s, the early 70s, Rutgers was all male, the undergraduate school. There was Douglas College, which was very fine, only women. Our client was a gardener in New Jersey who had a son and a daughter. His son was admitted to Rutgers. His daughter, who had better grades than her brother, was turned down from Douglas. Rutgers is a state university. The simple case was the state is providing educational opportunities for men, many more opportunities than it is for women. It was a hard situation because the faculty, the dean and the faculty at Douglas were very much opposed to the admission of women to Rutgers. But in the end, both institutions survived. It was pretty much like Barnard and Columbia. Columbia started to admit women. Barnard College is still in existence. Douglas is still in existence. Then there was the summer and engineering program at Princeton. Princeton had, a few years before, started admitting women. But the summer and engineering program was designed to turn children at an early age, it's for 6th graders, onto science and math. They had an enriched program in the summer, and they were followed up in the school year. It was a great program, but there was one thing wrong. It was boys only.
Right.
And there were so many ironies in those days. When I suggested to Princeton that we ought to be able to change this without making a federal case out of it, the answer was, this is a very intense learning experience for the children. We can't have the little boys be distracted by the presence of little girls.
When I visited you in your chambers, which was really an extraordinary experience, you explained to me that this was Thurgood Marshall's, it had previously been Thurgood Marshall's chambers.
Yes.
And as a labor and employment lawyer, I find it fascinating that you, when you were the director of the Women's Rights Project, used an incremental strategy that's been compared to the strategy that was used by Thurgood Marshall on race discrimination, just step by step moving the law along. Could you talk a little bit about that when you were at Columbia and being the director of the Women's Rights Project, the strategy you employed?
Go back to 1971. The Supreme Court had never seen a gender-based classification that it thought was unconstitutional. So we can take the two leading precedents. One was a case called Gossett against Cleary. It was a woman who owned a tavern, and her daughter was her bartender. The bartenders' union didn't like the idea of women serving as bartenders. So Michigan passed a law that said a woman could not be a bartender unless her father or her husband was the owner of the establishment. So that put this mother and daughter out of business. But the Supreme Court said that law was okay because bars tend to be dangerous places, and we can't allow women to be exposed to such a risk. Now, no one thought that the people bringing drinks to the table were women, much closer to the men who had one too many. It was only the bartender's job. But it was a very flippant opinion by Justice Frankfurter. Then the next leading case was in 1961. Now we're in the era of the Warren Court. It's made so many strides. The case is Gwendolyn Hoyt against Florida. Gwendolyn Hoyt was what we would today call a battered woman. And one day her husband had insulted and humiliated her to the breaking point. She turned and saw in the corner of the room her young son's broken baseball bat. She took it and with all her might, she hit him in the head, fell over. That was the end of her humiliation, the end of the husband, and the beginning of the murder prosecution. Gwendolyn Hoyt's idea was, if there were women on the jury, not that they would acquit her, but maybe they would convict her of the lesser crime of manslaughter instead of murder. So she was convicted of murder by an all-male jury. Oh, I should say what Florida's system was. Women were not called for jury duty at all. They were not on the rolls. If they wanted to serve, they could volunteer. Well, you can imagine how many people would volunteer for jury duty if they could escape it. So her argument was that the jury selection system denied her the opportunity to be judged by a fair section of the community. The fair section would include in the pool at least as many women as men. When that case came to the Supreme Court, the court wrote an opinion that said something to this effect. We really don't understand this complaint. Women have the best of all possible worlds. They can serve if they want to, and they can be exempt if they want to. You can imagine Gwendolyn Hoyt being told that that was what the Supreme Court said about her complaint, not at all thinking about her plight. That was it. It was so clear what the system was saying. Jury duty is an obligation of citizenship. And if you are a full citizen, you have obligations as well as rights. The state was saying, women, they are expendable. We don't need them to serve in the justice system. So all that got changed in the 70s. But that's the precedent we were facing. The perfect case turned out, and it was found because a man who was then one of ACLU's general counsel and a great lawyer, Marlon Carpathian, he was a regular reader of Law Week, and he found a case just decided by the Idaho Supreme Court. It involved a woman named Sally Reed, whose teenage son died under tragic circumstances, and she applied to be appointed administrator of his estate. Not because there was any financial advantage to her, but for sentimental reasons. The boy's father, Sally's former husband, applied a couple of weeks later to be administrator, and the probate judge in Boise, Idaho said, "Sally, I'm sorry, but the law gives me no choice. It says, as between persons equally entitled to administer the decedent's estate, male must be preferred female, period." As simple as that. So here was a woman with quite a compelling case, and her case illustrated what was wrong with the system. She had had custody of her son when she and her husband divorced, because the son was then what the law called of tender years. Then when the boy reached his teens, the father applied for custody, and the family court judge said, well, now the boy needs to be prepared to live in a man's world, so the father should have custody. So Sally told that she was no longer the better custodian of her son, and then being told she's not qualified to take care of what little he left. So this case comes to the court in 1971. The women's movement is revived in the country. And the Supreme Court, no longer the Warren Court, but the more conservative Berger Court, unanimously declares that law that says men must be preferred to women, declares it unconstitutional. So that was the starting case. Now, I have been criticized by some for bringing not only cases involving women, but cases involving men. And I've always considered that a kind of a bum rap, because all of the cases were about the discrimination that women encountered, but sometimes the male was the one who was the plaintiff in it. And a few years after Sally Reed's case, there was a case involving a man named Stephen Weisenfeld, whose wife was a teacher. She had a healthy pregnancy. He was teaching up to the 9th month. She went to the hospital to give birth, and the doctor came out to report to Stephen, you have a healthy baby boy, but your wife died of an embolism. So there, Stephen was left sole surviving parent of an infant. He vowed that he would not work full-time until his child was in school full-time. So he figured between working part-time and Social Security, he could make it. So he applied for what he thought was a benefit available to a sole surviving parent with a young child in his care. He was told by the Social Security office, this is a mother's benefit, not a father's benefit. You don't qualify. So that was a case where we had three arguments. One, the root of the discrimination is against the woman. She pays the same Social Security taxes as the man. the government doesn't give her family the same protection that it would give to a man's family. It's discrimination against the father, against the man as parent, because he doesn't even have the opportunity to personally care for his child. The majority, in an opinion written by Justice Brennan, said, we see where the discrimination begins. It's the woman as a wage earner. And another group thought the discrimination is against the male as parent, as Justice Stevens was in that group. Then there was one, it was my dear former chief. He was then Justice Rehnquist. It was the only time I ever voted on my side. And he said, this classification is utterly irrational from the point of view of the baby. Why should the baby have a chance to have the personal care of a parent if the parent is female, not if the parent is male? So the cases were, none of them were made up. I mean, these were real life people, and I think it speaks well for our system that they thought a wrong had been done to them, and that we had a system of justice that could right that wrong.
Well, one thing I thought was extraordinary, speaks to you as a person, that you stayed in touch with Reed until she died, and Weidenfeld you're still in touch with. Yeah, and you still exchange correspondence with some of these folks that you brought these cases.
Yeah.
It's extraordinary. So we covered the Supreme Court. So you were appointed to the U.S. Court of Appeals for the D.C. Circuit in 1980. What made you decide to take the leap from being a professor and an advocate at the ACLU to go into the judiciary?
President Jimmy Carter. When Carter became president, he looked around at the federal judiciary and thought to himself, they all look like me. But that's not how the great United States looks. So he made a concerted effort to appoint members of minority groups and women in numbers. When he became president, there was only one woman sitting on a federal court of appeals. She was Shirley Hofstadter. He made her the first ever Secretary of Education. But he vowed that he would change the complexion of the U.S. judiciary. He had only 4 years. He had no Supreme Court vacancy to fill, but he appointed over 25 women to U.S. district courts and 11 women to U.S. Courts of Appeals. And I was one of the lucky 11 in that group. The people asked me, did you always want to be a judge? And I explained what I wanted when I got out of law school was a job. So that was, I never, it would have been totally unrealistic to think of becoming, that I would become a judge until Carter. And no president ever went back to the way it was. So Reagan didn't want to be outdone. He wanted to appoint the first woman to the Supreme Court. He made a nationwide search and came up with a brilliant choice, Sandra Day O'Connor. But it was interesting that in the fall of 1980, I think President Carter sensed that he was not going to win the election. But he said he had a reception for the women he had appointed to the bench, and then Secretary of Education Hofstadter, who would have been his choice for the Supreme Court if he had a vacancy to fill. And he said that he hoped he would be remembered in history for how he had changed the federal judiciary. He deserves tremendous credit for that.
And I just read that you were quoted a couple of days ago about saying that you're optimistic about women in the judiciary and the future of women being appointed to the judiciary.
Yes, and now we've had a couple of federal circuits that have had one woman chief judge follow another. It's Stephanie Seymour and Danelle Taha. So many of the circuits have had women, not only, they all have women, but many of them have had women as chief judges.
So what was it like for you when you first started on the court? I mean, last year we had Judge Wald, who was a legend, and she talked about how it was for her. And what was it like for you just becoming a new judge?
I was appointed to the Court of Appeals about 8-9 months after Judge Wald. And my very first sitting, there's Roger Roberts presiding. Pat is to his left and I'm to his right. Pat asked the question. And some minutes later, I asked the question. And even though my name is in front of me, the lawyer responded, Judge Wald. They knew there was a woman on the D.C. Circuit. And her name was Judge Wald. And I had the same experience 13 years later at the Supreme Court. But invariably, every term, one lawyer or another would call me Justice O'Connor. Although we didn't look at all alike. You wanted to confuse people, I would pick Briar and Souter. And then at social gatherings, when I was introduced as Judge Ginsburg, as often as not, the hand would go out to my husband. But 2 is my lucky number because I was the second woman appointed to Rutgers faculty, second woman to D.C. Circuit, second woman to the Supreme Court.
Yeah, I remember. There was Eva Hanks was the other.
Yes.
She was the
She taught property.
Property. Yeah, incorporeal heterodidyments. I remember that very well. So you received some very good advice from the Chief Judge, Edward Tam, when you first got onto the circuit court.
As I give that advice to people who ask me, is there any decision that you regretted? Well, Judge Tam said, this is a challenging job. You should do the best you can with every case. But when it's over and the opinion is out, don't look back. Don't worry about the past. Go on to the next case and give it your all. I think that's very sound advice for a new judge.
Yeah. And I did want to note, I think you argued six cases before the Supreme Court and you won 5.
Mm-hmm. Petitions many more, but
that's very good. So then you were appointed to the Supreme Court, and I remember President Clinton referred to you as the Thurgood Marshall of gender discrimination law.
that's vast exaggeration. It's a huge difference. My life was never in danger when I was arguing cases.
We had Mr. Coleman here several years ago as a legend, and he discussed a lot about the struggle that they went through. But still, at the time, even though your life wasn't threatened, you were doing extraordinary work. How did you find the Supreme Court when you first arrived there?
collegial. It is, in fact, the most collegial place I've ever worked. If you think about the federal court system, the real power holders are the district judges. They sit alone in the courtroom. We have a firm final judgment rule, so you can't go up on appeal every time you don't like how the district court ruled. Then you go to the Court of Appeals level, and as an individual you have no power unless one other judge agrees with you. In the Supreme Court, you're powerless unless 4 colleagues agree with you. So 5 is the magic number in the Supreme Court. I mean, the routine of preparing for the oral argument, writing opinions, that routine is very much the same as it is in the Court of Appeals. The luxury that the Supreme Court has is we decide what we're going to decide. So I think roughly 1/3 of my time is spent with the petitions for review, the cert petitions.
I'm curious, with your background working for the ACLU, how did you get through the nominations process back then?
It was a different time, and it's a time I hope we will return to. And I was the beneficiary of it, and so was Justice Stephen Breyer, who followed me by a year. Now Vice President Biden, then Senator Biden, was the chair of the Judiciary Committee. But my biggest supporter on the committee was Orrin Hatch. After the first day of the hearings, he called me and said, "Ruth, some of my colleagues think we weren't rough enough on you, so we're going to ask you harder questions tomorrow." It was, the committee was very concerned about its reputation. The nomination before mine was Justice Thomas, and the committee did not perform very well in that. So they initiated a new proceeding. If there's anything in your record that's questionable, you meet behind closed doors with the members of the committee, and you have an opportunity to answer whatever damaging information they've gathered. Well, for me, it was absolutely nothing. So the question I got asked is, what would you do to improve the hearings? Now, I hadn't been confirmed at that point, so it's not likely to be very, very critical. But the bipartisan spirit that prevailed at the start of the 90s is the way it should work. And my White House handlers were very concerned about my ACLU connection. So when we were doing these, they call them murder boards to prepare for the hearing, members of the White House staff played the part of various senators. So the questions went like this. You were on the ACLU board from X year to X year. During that time, they passed this or that resolution. How did you vote on that resolution? And I said, stop. There is nothing that you can do that would lead me to badmouth the ACLU. So that was it. There was not one question, not a single question from the committee about my ACLU connection.
It's extraordinary.
Which is as it should be.
Yeah. So, on the Supreme Court, what case have you decided or participated in that has meant the most to you personally?
Jeffrey, that kind of question is like asking which of my 4 grandchildren.
Okay, which of your 4 grandchildren do you like the best?
Well,
or which case did you dissent from?
Some of my dissenting opinions are my fondest. So I won't speak about it this term, but we'll be following the papers next week. One of my all-time favorites was Lily Ledbetter's case.
Right. There are a number of employment lawyers.
Well, my colleagues simply didn't get it. Here was a woman working as an area manager with a Goodrich tire company, a job that was predominantly male. She starts working in the late 70s. One day somebody leaves a slip of paper in her mailbox, and it has just numbers. The numbers were the salaries from everyone in the plant who was doing that job. The most junior man was earning more than